any mention? May I please, Your Lordship, I beg to mention item number 5, my lord, the main hearing list. My lord, I'm praying if this matter can be taken after 2 weeks, my lord. Paul has
I
some
think this matter was
hard
hard part.
yes, my lord.
I think your submission is over, isn't it?
Is complete, my lord. It is for them to reply. However, my lord, I'm praying for some time today.
Have you sought consent of the other side?
My lord, I was looking for them, but I haven't seen anyone from since.
What to do?
I'll inform them, my lord. If Your Lordship allows, I'll inform them.
On pre-made by petitioner. This is matter up to 2 weeks.
And you are blessed. From supplementary causes, item number 1.
Yes.
Come. Shh. Taken steps?
Yes, we have taken steps.
Yes, Dr. Muzika. You have entered appeal?
Just today's occasion. I'm requesting for some time for instructions.
You see, I think this is off the record. But yesterday, I think I read in the newspaper.
I'm giving, Lordship, that is the judgment.
Is this the Supreme Court?
This is the one, yes.
Where no, not this court, not this, but what the newspaper said, the Supreme Court has come down heavily on the
This is the judgment.
Assam.
This is the
government.
judgment.
No, this is West Bengal. What?
Sorry, not exactly this judgment. That is coming up later.
That's for deportation of
Deportation of the 63
of foreigners, or Bangladeshis for that matter, who have been identified as such.
Yes.
Why is it taking so long and all those things?
And this particular matter, Lordship, is again listed today in the Honorable Supreme Court. Lordship, can you just not for any other purpose, but just to read para 18.
What does it say?
Lordship, the notification the Lordship had given us on 27th January.
Oh, yeah.
So this particular paragraph take care of clause 2(5) of that notification, 2009.
What does it say?
And relevant part is para 19. 18 is the cognizance of the same notification your Lordship gave it to us. So the matter will be, we'll have to wait for the outcome what happens today.
But this matter is posted today?
Today. 18 is the cognizance as the Lordship rightly held, and 19 is
30 days.
30 days. So Lordship, we have a situation provided my learned friend is appearing to the first day. Situation like, because if there is no detention center in Meghalaya, so normally the normal courts will decide. Unlike in Assam, the Foreigners Tribunal decided, same under 14B. But the power is not with the session of the magistrates, it's the Foreigners Tribunal. Now what happened in Assam was, Lordship, Foreigners Tribunal decided and held them guilty, 14B. Now they could not be deported for more than some number of days, which was reported in the paper history, because they could not find the addressee of the addressee. Supreme Court came out very heavily saying, asked the Chief Secretary to appear in video mode, saying kindly apprise us whether you have to comply with this 2(5) or not. Of the same notification your Lordship said. Conviction by tribunal. Now we have a slightly different situation in Meghalaya. We don't have a center. There is no foreign tribunal here. And in spite of the fact there is a direction, so the central government can apprise in the next date whether in that situation what can happen. So that we leave it to the inputs from central government. But so far Meghalaya is concerned, the normal, though Foreigners Act law is set into motion, but the detention center is not there, so they are kept in judicial custody and police custody. And the trial is not done by the tribunal here, it's done by the normal courts.
Dr. Muzika, I think you will be called upon to assist.
I'll give you a comment.
As far as the detention centers are concerned. What has the union done so far, or the state for that matter? For
at least that input from him will be very important. Yes.
Detention center, it's a must.
It's a must.
Considering the activities that we have seen, the speed of activities. Yes, in our state. Somebody coming, going.
Lordship, the para 19, if I just clarify, the Foreigner Tribunal has held them guilty. Now, the Honorable Supreme Court has relied back on the notification your Lordship has given it to us. And it says, as per this, you have to deport them within 30 days.
Exactly.
Once found guilty, you have to deport them. No, and then the Supreme Court yesterday came out very heavily saying you can't find the addresses of the convicted Bangladeshis. But kindly submit a report that is coming up today as to what have you done and what is the reason for not reporting.
See, according to the Foreigners Act, can there be a summary trial?
It is quasi actually.
Like in this case, you see, person coming from Bangladesh, in fact, the petitioner here, they have not denied that they are not Bangladeshis.
Yes.
They have just come for some other purpose.
Yes.
So they say, yes, we are Bangladeshis.
Correct.
We do not intend to stay here. As soon as our
For
puja
some
as soon as
reasons,
our puja is finished, we will go back.
we'll go back. Yes.
If there is summary trial, they have been apprehended, no doubt, without papers. They have violated the laws.
Correct.
What is to be done is, if a summary trial is there, within one day you can decide the matter,
Yes. Yes.
confirm them as foreigners, foreign nationals, and deport them.
So, Lordship, that's what the para 19 clearly says. Once you do that, if they admit, there is a question of sending them to tribunal, or there is a question of, that is a different aspect of the matter. And what the tribunal does, or the normal courts does, they've come and they are illegally involved in some crime. So there has to be a distinction.
Yes.
Then
That
yes.
is a different thing.
So that situation, Your Lordship, if the Union of India at least clarifies on that, it will be easy for the state even, and it will be for the court to at least pass in appropriate direction.
Yes, if such a foreign national, like you rightly said, is apprehended,
Commission of an offence under the Indian
offence,
Penal Code. Yes.
that takes a different turn.
Different
altogether.
turn.
But
Within section 2.5, which Your Lordship relied heavily in, which is in para 18 and 19, the entire 2009 notification has been quoted in the judgment. And specifically on 9, the direction. So today the matter will be taken up, Your Lordship. Let's see what happens tomorrow. So in the meantime, my friend can just be easy for the state. I have given a copy.
You have given a copy?
Yeah, I've given a copy.
I'll require the 2 weeks time.
Take no issue. It's a matter of slight urgency and importance.
Why 2 weeks time? 1 week's time is good enough. Concern, you need detention. They are in custody.
My lord, they are in custody.
Dr. N. Musika, the SGI has entered appearance on behalf of the newly pleaded respondent, Public Union of India, and has prayed that some time may be given for specific instructions to be received in this regard, as far as this matter is concerned, as far as this case is concerned. On this prayer not be objected to by the parties present, matter is adjourned. List the same on this 17th.
So 2 weeks.
17?
But I'm trying a little longer. 24, 25.
25th.
Okay.
Item number 3.
It's connected, my lord. Item 2 and 3 are
Same.
connected.
Connect.
Same order.
Connect.
From daily list, item number 1.
May it please Your Lordship. Your Lordship, vide the impugn order dated 28/11/2024, my Lord. The learned appellate court, my Lord, was pleased to dismiss the appeal filed by the petitioner, my Lord. Now, my Lord, the brief fact of the case is that, my Lord, the respondent, who was the plaintiff in the trial court, my Lord, had filed a suit of recovery of money, my Lord, for an amount of rupees 49 lakhs, my Lord, on different dates of transaction, my Lord, 49 lakhs. And, my Lord, the petitioner here, who is the plaintiff, my Lord, has filed a WS written statement in the trial court, and finding that the suit was barred by limitation, they have filed an application under Order 7, Rule 11, that is for rejection of plaint. My Lord, the learned trial court, subordinate district council court, had dismissed the application under Order 7, Rule 11, and the plaintiff, or the petitioner herein, who is the defendant there, has also challenged the order, my Lord, before the appellate court.
When have you filed that initial application?
The initial application, Order 7, Rule 11, my Lord, in the trial court. We have filed it, my Lord, find it at page. My Lord, is at page 124. We have filed it on. We have filed it in 2020, my Lord. This is a suit of 2020, my Lord. And, my Lord, it was this application was rejected by the trial court, my Lord. The rejection order is at page 171, my Lord. that is on the 27th October 2020, my lord. It was rejected by the subordinate court. Then thereafter, my lord, the petitioner herein, who was the defendant there in the trial court, has challenged the order before the appellate court, my lord. Now the appellate court, my lord, while challenging the order, which is at page 23, my lord, but the operative part is at page 50, my lord.
50.
Yes, my lord. Page 50, my lord, the operative part.
Yes.
My lord, the learned appellate court, my lord, on two grounds has made the observation. Number one is that, my lord, reading the operative part, my lord, after number 1, 2, 3, 4, line number 4, my lord, I am hereby of the opinion that the money transaction should be considered as the time for counting the period of limitation, but the cause of action has to be taken into consideration. Furthermore, as per Chapter 4, Civil Justice Rule 34 of the Law of Administration of Justice in Meghalaya, read as under, except in so far as provided by these rules, the Indian Limitation Act 1908 Act 1908 shall not apply suits in which either or both parties are members of a scheduled tribe or tribe specified in item 1 and part 1 Assam of the schedule of the Constitution, Scheduled Tribes Order 1960. My lord, these are the observation of the learned trial court. Now my ground is that, my lord, my first ground is that the Limitation Act 1908 is not applicable in the suit of tribal that is against the judgment, my lord, of this honorable court passed by the full bench judgment, my lord. I will supply the judgment to you. My lord, here's the judgment. My lord, the observation by the learned appellate court at the limitation...
We'll not go into the facts of the case.
Yes. Yes.
You take steps for issuance of notice.
My lord, and there is an application also, my lord, a miscellaneous application for stay, my lord.
Let the even for that also the respondent has to appear.
But my lord, the Limitation Act is applicable in the state of Meghalaya, my lord. Now this full bench judgment says that the Limitation Act is applicable, my lord. Now the learned trial court is saying that Limitation Act is not applicable.
That will be considered
Yes,
when
my
the
lord.
other side appears. This court cannot pass an ex parte order. If you succeed, everything will be reversed.
Yes, my lord.
You will succeed on the basis of your on the strength of your case.
Yes, my lord.
If
My
not,
lord,
then it becomes pointless at this point of time, even to pass an interim order.
just my humble submission, my lord, since the application is for rejection of plain, my lord, and it's under Order 7, Rule 11. Now, if my lord will not stay the proceeding of the trial court, now the proceeding will go on, my lord. The evidence will start. So now Limitation Act is applicable because subject to 711, my lord, it is applicable, my lord. So since it's applicable and the rejection of plain also, my lord, this that has been dismissed by the appellate court, my lord, then it'll affect the trial. So my lord, I would pray before your lordship to
When
kindly...
is the next date fixed?
My lord, the next day will be fixed in the month of February, but the date has not been ascertained in the learned trial court, my lord. So kindly, my lord, stay the proceeding of the learned trial.
You take step for issuance of notice. I'll hear the other side.
Yes, my lord.
We'll give you a short date for that.
Yes, my
I'll
lord.
give you a short date.
Yes.
You may take step even by Dusty if you
Yes, yes, my lord.
heard. Listen, there are counsel for the petitioner. This petition is accordingly admitted. The petitioner is directed to take steps for issuance of notice on the respondent. Have you filed a separate application for stay?
Yes, my lord, I have filed the separate application.
No. Upon the only one respondent,
Yes, my lord.
on the sole respondent. even by Dusty, if so desired. The notice is in view of the prayer made by the petitioner for grant of an interim order in this case, which prayer have been made in a separate petition. The notice is made returnable within 1 week. Let steps be taken. This is matter on Son R 18th.
Highly obliged, my lord.
Item number 2.
Lordship, in this case, I got the instruction. There's only 13 persons yet to be make payment, and 179 already completed, and 13 due to this because of fund. Now fund is not there. When fund will come, then it will be done. This is the instruction to me.
Within this financial year, perhaps maybe complete.
We'll keep it after 3 weeks, Lordship. I'll take instructions also on the basis of his.
Yes, sir, give me this.
Give it.
Give him a copy. So now what is left is only of 13.
On 13. Only shortage of fund, nothing.
Mr. R.W. CGC has produced communication dated 5/2/2025 issued by Mr. Shri Rahul Soni, Colonel, by Colonel Rahul Soni, Chief Law Officer, wherein the latest status report of the bills in respect of the petitioner has been given to indicate that out of the total number of 192 the said communication is hereby brought on record and marked as annexure Y. No, why not done them? X what done tiny annexure Y. Unum to last line. Out of the total number of 192 petitioners, the bills of 179 have been passed and only 13
Passed and paid, you
have been passed and paid, and only 13 of them are left. That is because of paucity of funds. The Leonard CGC has, however, submitted that as and when the funds are made available, the matter will be processed expeditiously. Next, Mr. P. Nongri, Learned Counsel for the petitioner, has sought for time to seek instructions as far as the said status report is concerned. On premium, this is not up to 4 weeks.
4 weeks.
That'll give you enough time.
Lordship. Obliged.
Item 3.
Item 3.
Same.
Same.
Item number 4.
This one.
Go for TV now. He has come on, Archie. No, no,